Okay, so I sent out an announcement, I think it was yesterday, that I'm going to, unless I had an emailed objection record for today, because spring break is starting. Well, I mean, it's not now, but it's starting soon, and I suspected that there was a good chance we wouldn't have everyone here. So I thought it might be good if I just recorded it and then uploaded it later. I'm gonna go ahead, give me 1 second, and I'm gonna pull up my PowerPoint. Um, I have my camera off today because actually I am sick and my 3-year-old is sick. I got sick first and then she was sick this morning. So you might hear her in the background, and hopefully, hopefully that's not too distracting, but it could be. Um, so my goal today is basically to take us through um our legislative piece. I'm not like we are a bit behind, so I'm going to try to march us through a certain amount. But I think that it shouldn't be too hard to get through. I'm probably what my goal is to focus on case law and to move some of the impeachment stuff, which was assigned recently, to another day, because I think that that will fit together nicely, as a sort of bridge between the executive um, and legislative. But that's my goal. So let me go ahead and share my screen. So let me know if I'm not in the appropriate place. But what we had been doing was working on McCullough v. Maryland, and it actually took us some time to work through, largely because it was it's a very theoretically heavy case, because it deals with two major important clauses. One is the necessary and proper clause, and the other is the supremacy clause. And we've dealt with the supremacy clause before, right? Because we looked at it particularly in Marbury v. Madison. The necessary and proper clause was new to us. And one place I want to kind of touch on before we move on, McCullough, remember, is the one that establishes the sort of inability of a state to tax the national government. And the first part of it deals with whether or not a national bank is legal, constitutionally, I should say it's constitutional. And it's found to be, because of the use of the necessary and proper clause. It's seen as something that is necessary and proper for Congress to legislate about, because it is an extension of the explicit powers. It's an implied power. And on the PowerPoint, we went through some parts where we talked about the differences and how Jefferson and Hamilton thought about the national bank, and also how they interpreted the meaning of necessary. And it's Hamilton's meaning of necessary that prevails. He sets up what is called the means and scrutiny test, which becomes really important for us later, where you look at the means that the government is using and the end that the government is meant to obtain, and you see their relation or lack of relation. So the way that Hamilton defines necessary is as the relation between the measure and the end, between the nature and the mean, employed toward the execution of a power. And the object of that power must be the criterion of constitutionality. With regard to the supremacy clause, like I mentioned, we already saw that in Marbury play an important role. But it's just returning to this idea that there's a supremacy of the federal structure, that the laws of the Constitution, they're more than laws in a sense. They are the source of law. They are of a higher status, right, than just the types of law that we pass in state legislatures or even Congress. The idea is that the power to create is the power to preserve. So if this is what Marshall says, if the government has acknowledged that the Constitution basically founds it, creates it, then it is the federal government, which was the agent of the creation, that also has the power to preserve the union or to preserve the nation. And so if something threatens that, like a state taxing the federal government, then it's not going to be something that we think of as constitutional. One of these sort of extensions here that you see then is that the power of taxation is explicitly mentioned, right, as a national power of Congress. And so Marshall interprets this to mean that taxation in a lot of ways is essential to the very existence of government. So it's not that states can't tax, but the idea that a state could tax the federal government is going beyond what the supremacy clause allows, right? Because if taxation is essential to government and you're letting a state government tax the national government, in a way you're saying that the state government is trumping the federal government, and that would be something that violates the supremacy clause. One thing I wanted us to spend time with, I did mention this, but I just want to hit on it again, is how John Marshall, right? He's the one who wrote McCulloch v. Maryland. How did he think about the decision that he wrote? Because after it was written, it was a controversial decision. The sort of concern that people had was that it was going to be something that is used and abused, right? That he made the grant of power in the necessary and proper, in his interpretation, the necessary and proper clause too broad, right? And so that Congress can basically do anything. What he says, because he didn't give like a public interpretation of his decision under his name. He gave a public interpretation, though, in a newspaper, a Virginia newspaper, where he wrote an op-ed as somebody else. Okay, so he's using a pseudonym so that the public didn't know it was him. And this is how he explained what he saw himself doing. He said that it's true, right, that the necessary and proper clause is giving Congress a substantial power, but that there's a part of the decision in Marbury, which he wrote, right? But he's not saying he wrote it because it's the op-ed where he's using a pseudonym. But there's a part of this decision in Marbury that is under recognized or undervalued. He says the court can strike law if, quote, Congress, under the pretext of executing its powers, pass laws for the accomplishment of objects not entrusted to the government, because it would become the painful duty of this tribunal to say that such an act was not the law of the land. Okay, so he does say here, right, that there's a part of the decision, and again, he's writing this under a pseudonym, so we don't know it's him. He says there's a part of the decision of McCulloch v. Maryland that is putting a limit on what the Congress can call necessary and proper. And I think that's right. I mean, I think that's definitely textually right. I don't know if that's how things develop over time, but it is true that there's that boundary there. The next case that we're looking at is Powell v. McCormick. It's a much, much later case. And sort of what we're doing in this unit on the legislature is looking at the power, right, that Congress has and the power that it doesn't have. That's why we start with McCullough v. Maryland, where we have this discussion of necessary and proper, right, and the importance that that clause has in determining what Congress can do constitutionally, what it cannot do. Powell v. McCormick is another case where we're looking at the extent of the powers of Congress, what is possible for them constitutionally and what is not possible for them. And it's important to remember that when we were at the phase of drafting our Constitution and sort of the philosophical milieu that is behind this era, the branch that is seen as being the most dangerous, generally speaking, I mean, there are outliers who had different opinions, but generally speaking, the idea was that the legislative branch was the most dangerous because the biggest danger in a Republican democracy is majority tyranny. So the branch that is closest to the majority, i.e. the legislature, is the one that is dominant. It's supposed to be dominant by the nature of the government, but in that sense, then it can pose the most danger. So we're looking through and we're sort of seeing, okay, well, what can Congress do constitutionally? Is it really so dominant? Powell v. McCormick is this case. It's a very interesting contrast to the case we look at afterwards, which is the U.S. term limits v. Thornton down here. It has to do with the qualifications of our representatives. And that doesn't sound like it's super important, but here's one reason that it's really important, aside from just the practical matter of having a sound understanding of what qualifications our representatives have to have. It's also got this dimension to it where you're dealing with a question of basically the sovereignty of the people to choose who represents them. You're weighing that against Congress's institutional ability to determine who can be in Congress and who can't. And Powell v. McCormick is a case where these two values come into conflict. So Congressman Powell, he gets in trouble for misconduct, but he still gets reelected. And it's very scandalous. You know, everyone kind of knows that he did commit the kinds of things he's accused of. It turns out later, I think, that his wife or his ex-wife is on the city's payroll, something like that. So it's very seedy, right? And he's reelected anyways. He was popular and in a lot of ways, I mean, I guess he was pleasing to his constituency. I don't think he would have had the sort of influence he did if he wasn't in some way. After he's reelected, the Democratic members of Congress say, no, we don't want this guy. He is corrupt and we don't want him to be a part of the Congress. So what can they do about that? He has been the one that is selected by his district. So what power do they have if they don't want him? What they do is they declare his seat vacant. So the House declares his seat vacant, and then the Speaker of the House refuses to give him the oath of office. So he doesn't get sworn in. Powell says that this two-step, right, of declaring a seat vacant and then refusing to give him the oath is unconstitutional. He says this is exclusion from the congressional body after he has been elected, and that there's not anything in the Constitution that gives Congress the ability to do this. So the lower courts dismiss this on jurisdiction, but of course things keep going. And the question is Congressman Powell's exclusion unconstitutional? Another way of looking at it is to ask, is the qualification of members of Congress list? So there's this part of the Constitution that lists what qualifications the members of Congress have to have in Article 1. So is the qualifications of members of Congress in Article 1 an exhaustive list? Meaning, is that list, like as long as you meet the requirements on that list, is that all that you have to meet? Or can Congress go back and add more qualifications? So another sort of way of asking, so the first issue is that I posed it in two different ways, really, to kind of show you from, I guess, two directions the summation of the question. The second issue is whether or not Congress has the power or the court has the power to determine Congress's qualifications. So you can see how this is a separate issue. It's basically saying, okay, it's not just a matter of interpreting the qualifications list in Article 1. There's also the question of authority. Who has the authority to determine what Congress's qualifications list should be? Is it Congress or is it the court? So in this case, the court says that this is an example of the court limiting the powers of Congress. The court says that the exclusion of Congressman Powell is unconstitutional, and that it's the court that has the authority to determine what are the constitutional qualifications involved for membership in Congress. Oh, I see someone in the chat. 1 second. Okay, so the holding to the first issue, the first issue is, I'm just posing it in two different ways. The sort of most direct way to ask it is to ask, is Congressman Powell's exclusion unconstitutional? But the implication of that question is whether or not that list, right, in Article 1 is exhaustive. And the answer to the most simple form of the issue, is Congressman Powell's exclusion unconstitutional, is yes, it is unconstitutional, which would mean that yes, that list, that Article 1 list, that it's exhaustive. Congress can't go and add to it. The second issue I wrote in a way that I'm trying to make clear that it's about different sources of authority. So that one is not yes or no. I could have written it in a yes or no way, but then I was afraid it wouldn't be clear what the alternative option was. So for example, I could have written it, does Congress possess the ability to determine Congress's qualifications? The answer would be no, but then it's not really clear what the alternative would be. So in that one, I said, does Congress or the court possess the ability? And then the answer would be the court. All right, good job. Thanks, Taylor, for asking. So one of the first things that comes up in this is actually a throwback to our unit on judicial review and on the judiciary. The idea, right, of the boundaries that the court has for itself on what it can hear and what it can't. Some people suggested that this case, Powell v. McCormick, was not justiciable, meaning that it's not something that the court can decide. And the court says yes, right? This is something that we can decide Article 1, Section 6 is something that exists not to stop judicial review, right, but to play a certain role in how the institution, the Congress, the institution of Article 1 functions. So they're saying, well, just get this out of the way, right? This is something we can talk about. Powell is correct that early on, because this is one of the things Powell argued, that early on, that the only reason you could be excluded, so even, back in 1787, was if you didn't have the qualifications that were laid out in Article 1. And that this is a very intentional move early on from Madison and Hamilton to sort of recognize the role that people play in electing who governs them. So then expulsion is a congressional power, right? That is something different than exclusion. So this is one of the things that one of the reasons this case is interesting is there's a process, right, to expel a congressional member. And you have to go through a certain procedure. It doesn't happen because it's not clear in the case of Powell v. McCormick that they would have had the necessary votes to do that, right? So they just decide to exclude him. They're not going to pick him up altogether. So this was, in a way, this was Congress kind of being sneaky, right? They're saying, well, okay, we have the power to expel. That's explicit in the Constitution, but the Constitution could be interpreted to mean that we could just exclude him. We could just say, you don't meet the qualifications. And the court is saying, no, that interpretation won't work. The basic principle of Powell v. McCormick, not just from the perspective of asking what congressional constitutional power is like, but from like the broad perspective of looking at the canon of court cases. The basic premise here is that the people should choose who governs them. The people should choose who governs them, right? And so if Congress is going to intervene by not just sticking to the qualifications that are laid out, then it's not going to be possible to say that this is a choice of the people. There's also the possibility that, and so this is something I think that you would pick up from reading the case itself, the excerpts. You also see in the way that the majority opinion is written that they're anticipating objections, right? So justiciability was one of the first objections that they anticipated. They dismissed it. They also deal with the objection that this is a political question, meaning court, you can't deal with this because this is something that has to do with politics and the elected branches, and you aren't an elected branch. So basically, let this be something that Congress sorts out for itself. You don't have any power here. And again, here the court says, no, that's wrong. This is not a political question. So this does not satisfy the criterion for being one of those boundaries that we put on ourselves of when we decide to take a case or not to take a case. We do need to handle this part of the Constitution and explain in a way what it means. It's underdetermined, and a real constitutional issue has arisen as opposed to a political question, right? So we have to do this. So why does this part of the Constitution have to be interpreted? Well, the Constitution says that Congress is the only one who can can judge its qualifications for membership, right? But it also lists the qualifications for membership. So it seems the implication seems to be that not that they make up the criterion of judgment, but that they apply the criterion. Actually, that may be. Okay. Secondly, along with that distinction, we also have the clear direction from the text that Congress can expel, right, with 2/3 vote of each house. So the only way to like absolutely determine qualifications then is through expulsion. They don't get to make up the qualifications themselves. What the mechanism they say that the Constitution lays out is, here are the qualifications. These are like your ways of dealing with the qualifications. You can apply the sort of basic qualifications and see if someone has them or not. And if they do and you don't want them, there's really not anything you can do about it. Or you can go the route of expulsion, which we have provided for in the Constitution with a 2/3 vote of each house. And if you can make it over that hurdle, then you can expel them. So this is the only way. These are their only options, basically. So they don't, in other words, they don't have the option of getting someone elected, presented to them, and then saying, oh yeah, we're just not going to give you the oath. Okay, that's not an option. Congress was trying to exclude him, but that's not a constitutional power they have. The only constitutional power they have is expulsion, and they didn't go that route. Again, this is in a way not just telling you what Congress's abilities are or aren't, but it's telling you about the sort of role or importance of the federal system and the choice of the people about who represents them being something that the national government can't really interfere with. In a way here, you could say, oh, okay, so then this is a state rights case. This is a state power case, because we're recognizing the sovereignty of the state, right? To say, this is who we want, and Congress cannot tell us otherwise. But actually, the more nuanced way of looking at it is that it's not so much about state power, though in the federal system, this particular expression is manifested through a state, right? A state's representative to the federal government. It's really about the people's power. And the reason that this becomes clear is in a later case, U.S. Term Limits v. Thornton. So remember, I told you these cases are like a pair, right? So this is another example, right, of kind of creative ways of getting around the Constitution when it comes to the matter of representation. So Arkansas, what they did is they want to limit, right? They're giving term limits to the representatives and senators, right, that are representing them on the federal level. And what they do, the way that they can do this, the sort of mechanism that is at this point at least not ruled out, is for them to say, yeah, we're just not going to put your name on the ballot. If you go past, 3 terms for representatives, 2 terms for senators, then we're just not going to put you on the ballot and nobody can vote for you. The problem is that the states are not given congressional power to impose state limits. Okay. And the federal constitution doesn't require term limits, right? So in a way, Arkansas is trying to get around the fact that there is no power for a state to say, okay, we're coming up with term limits. And also, they're trying to get around the fact that the federal government itself doesn't, enforce term limits. So their solution is to make this amendment to the state constitution about, okay, if you get past a certain number, we're not putting you on the ballot. So Bobby Hill of the Women's League of Voters in Arkansas says that this isn't an unconstitutional amendment that Arkansas has made. And she points out different parts of the Constitution that might conflict with, right? So this is a good example for us of where you remember how I told you a lot of times in constitutional law, when you're looking at the arguments and such that are made in the early parts of the case, the early parts of the process, I should say, you have a bunch of things people are trying to throw at the wall and see what sticks, right? So she says, is Amendment 73, Section 3 constitutional under Article 1, Section 2, Article 1, Section 3, and the 17th Amendment? Okay, so Article 1, Section 2 has to do with the qualifications of a representative. I've pulled it up here. I don't know if you can see it, but it's pretty long, right? But it's there on hyperlink if you want to look more closely at it. Article 1, Section 3 is what discusses how the state senators are chosen and how the states are expected to handle the election process. And then the 17th Amendment, which is a really important amendment that's from the sort of early progressive era, is an amendment that talks to us about the senators and how they're chosen, because originally the process for choosing senators was much more indirect. It was a process that came about through the activities of the state legislature. But after the 17th Amendment, which again is from the early progressive era, what we do is we can directly elect our 2 senators, and that's a big change. So those are the parts of the Constitution that she's pointing toward, right? And saying these different pieces, right, are what are making Amendment 73 constitutionally questionable. So is Amendment 73, Section 3 constitutional under Article 1, Section 2, Article 1, Section 3, and the 17th Amendment? The answer is no. So no, it is not constitutional. This is the reasoning. They go back to Powell v. McCormick, right, which has that famous line that I pointed you to. The people should choose who governs them, right? The people should choose who governs them. They say this is a fundamental constitutional principle, right? And so for Arkansas to make a state amendment about the sort of process by which the people choose who governs them, that is a violation of this principle. Okay. basically by changing their by changing their state constitution through this amendment, they're actually changing the text of the federal constitution. Okay, so it's a change that's occurring at the state level, but it's occurring in such a way that basically it's riding over or attempting to supersede what the federal constitution chooses to do. This is not an example of the 10th Amendment, right? Because remember, the 10th Amendment talks about the powers reserved to the states, like police powers. It says that there's what hasn't been mentioned, is reserved to the states. This is an example of this, right? Because we have already in the Constitution dealt with the discussion of qualifications, and we've interpreted this list as being exhaustive. So the 10th Amendment doesn't apply here. This is something that is discussed in the Constitution. It's not left over, so to speak. It's not left for the states to decide. Now, sort of the thing that you should be thinking is, okay, the people should choose who governs them. Powell v. McCormick, this is sort of the big principle. Well, isn't it the people who amended the Constitution of Arkansas? Well, that's the big question here, right? And we touched on this too when we were doing Baker v. Carr earlier in the semester. And we talked about some of the redistricting questions. What is the most basic unit of government? This came up in Dred Scott too. What is the most basic unit of government? Because if the most basic unit of government is the state, then you could say that a state amendment, right, like Amendment 73, is an example of the Powell v. McCormick principle, right? It's an example of the people choosing who should govern them. But if the most basic unit of sovereignty isn't the state, but the individual, right, then you couldn't say that Amendment 73 is an example of the people choosing to govern them, right? Because the sort of building block, the fundamental block, is the individual and not the state. So actually, Powell v. McCormick and U.S. term limits v. Thornton together can be interpreted to say that state-imposed qualifications, like congressionally imposed qualifications, also threaten the people's sovereignty. So whether you're talking about state-imposed qualifications on representation or you're talking about federal ones, it doesn't matter. They're all threats to people's sovereignty. It turns out, right, then, that it's the people's power that's being protected in these cases about qualifications, not the states, right? So that's how you should take that pair of cases. Gravel v. United States. This is an interesting case too, because this has to do with the speech and debate clause. This is again, it's a special power, right, that Congress has in the Constitution, and we're determining how far it goes or how far it doesn't go. So this is I think a really interesting case, and if you're interested in freedom of speech, it also has resonance for that kind of constitutional question. But we're looking at it here from the perspective not of freedom of speech necessarily, but of institutional powers. So the fact situation is that there's this thing called the Pentagon Papers, and the Pentagon Papers, I mean, I don't know if you're familiar with this part of history, but basically they're federal papers that are confidential, and they explain sort of dimensions of our involvement in Vietnam that were not generally known. And it's kind of information that in a politically charged moment, uh, like they were going through at the time, the fact that this information existed and was concealed and that it's different, right, from the information that was given to the public to get support for the war is really, 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 really explosive. Okay. So there's a senator, Mike Gravel, and he's dyslexic. The reason this is important is because he's dealing with the Pentagon Papers, right? And so he has trouble, right, with um, reading them on his own, right? He needs some assistance because of his dyslexia. So as with all of, the type of paperwork that he deals with to do his job, he makes use of a congressional aide, right, who helps him with the Pentagon Papers. And this is just a part of what, how he's fulfilling his role as representative, right, that he was elected to fulfill. So he does two things. He enters the papers into record at a subcommittee meeting, by reading parts of it. And it's going to be, his aide in part who is doing some of this. He also arranges private publication of the papers. So there's two different things. One is that the aide and him read parts of the Pentagon Papers into the Senate subcommittee record, which can then be accessed by the public, right? And then he arranges a private publication of the papers because he's saying that this is important information for Americans to know. As a part of sort of breaking down what happened with the Pentagon Papers and trying to hold people accountable for them essentially becoming public when they weren't supposed to be, a federal grand jury subpoenas the aide of Mike Gravel to testify. And this is a tricky part, right? Why didn't they just, subpoena Gravel? Well, under Article 1, Section 6, remember that big article I showed you, right? Where there's a lot of different explanations about the qualifications and powers and sort of activities of Congress members. There, one of the sections, one of the parts of Article 1, Section 6, one of the clauses is a speech or debate clause. And the speech or debate clause protects the speech and debate of representatives, right? The idea is that this clause means that afterwards, like after you've gone into your role as a representative and you're acting in your capacity of representative, that the things you say you can't get punished for later, right? So like let's say you criticize a president, and in the process of doing so, maybe you could get sued for some of the things you say, or penalized in some other way. Well, the speech and debate clause, in order to not let speech be chilled, protects the representative. So that's why he can't be subpoenaed. That's why his aide is. But he says, hold on, my aide is also covered by the speech or debate clause. So you cannot subpoena my aide. This is the question. Is a congressional aide protected by the speech and debate clause? And then the second separate question is a press protected by the speech and debate clause? Because then he also tries to extend the argument. So first he says, okay, look, you can't subpoena me. So you can't subpoena my aide because of the speech and debate clause. There's protections. But then he says, my decision to publish the Pentagon Papers through a public press is also a part of the speech and debate that I am constitutionally entitled to, right? Under Article 1, Section 6, speech and debate clause. So the first issue as to whether or not his aid is protected by the speech and debate clause is yes, he is or she is. And a congressional aid would be protected by this clause. The second issue of whether or not a press is protected by the speech and debate clause is no. The answer is no. Here's the reasoning. What is the intention of the speech and debate clause? Okay. The meaning behind it, the reason it exists, is basically to serve as a check on the executive, right? That there's independence of the people who are speaking and debating in Congress. They don't have to be afraid of holding the executive accountable. The way that our modern legislatures work, the court says, it's a very complex, it's more complex than it was at the time of the founding. And congressional aids are extremely important to how the legislature carries out its constitutional duties, right? So what comes into play here? Necessary and proper clause, okay? Congressional aids and their use in legislative duties, they're necessary and proper to it. However, you cannot make the case that the publication of the Pentagon Papers was essential to Senate deliberations, right? So you can say that the aid is essential to Senate deliberations, and so having the aid is necessary and proper, and so the speech and debate clause protects them. But you cannot say that publishing these papers publicly was essential to Senate deliberations, right? So if that's the case, the speech and debate clause doesn't cover anyone involved in that action, okay? And so you can't protect people involved in that action from subpoena. Here's the dissent. The dissent is basically saying that is way too narrow, okay, to make the distinction between the aid and the press. The aid, the court made the right call on the aid, but they made the wrong call on the press, because part of the role of the legislature, part of what it's supposed to do, this is according to the dissent, is to inform the people. And so in that case, then a part of what the Congress is supposed to do would make use of a press, like making use of a press would be necessary and proper. And so in that case, you would say that they are protected by the speech and debate clause. So in this interpretation of speech and debate clause, presses presses would be the sort of primary thing back then, but I guess now you might talk about news media or social media. And the sources that are used in these different mediums on this interpretation would be covered by the speech and debate clause. So that sort of jaunt through these cases. These are the things we're left with that I just kind of want to point out really fast. Some unique and important parts of the Constitution that mattered for these cases. The most obvious one is the elastic clause, or it's also called the necessary and proper clause. It depends on your professor and your textbook. That's Article 1, Section 8. Speech and debate clause, which we just talked about, Article 1, Section 6. Qualifications clause, which came up in both U.S. Thornton on term limits and Pelley McCormick is Article 1, Section 2. Then we have the 10th Amendment. Remember, we had to determine what role the 10th Amendment played in the Arkansas case. because the 10th Amendment has to do with the rights of the states, and the 17th Amendment came into play as well. 17th Amendment, again, is where our Constitution changed to permit direct election of senators. And the 17th Amendment's here, but there's a bigger link to it. There's a link to it earlier. I mean, all right, moving on to our next. So we're continuing with this theme of congressional powers. What we're really focusing on in this particular part is the powers that it has to investigate and to impeach. So Congress, in a lot of ways, is really, really, really boring. But in a lot of ways, it's a very interesting sort of political animal, because it has these functions of speech and deliberation and representation, but then it also has, it turns out, a lot of other kinds of things that it can do. And one of the things that the Constitution sets it up to do is to investigate, right? It has investigative abilities. And it also has the important role of impeaching, right? So it can impeach the presidents and it can impeach justices. So just to recap, so far, we've seen that Congress can make a bank. It's an expansion of its powers. Congressional aides are covered under speech and debate clause. It's an expansion of its powers. The qualifications clause are what is listed in the Constitution, right? And they cannot be changed by the states or Congress. That's a limitation of Congress's powers. Important constitutional concepts we've seen so far are supremacy of the federal system, right? And that came up a lot in McCullough and in US term limits. And then the elastic clause or the necessary and proper clause. Things that we've been spending time with, right, are talking about the electoral process, the process of deliberation, the relationship between congressional power and the states, and the relationship between congressional power and the Constitution, or you might say between congressional power and the Supreme Court's power, right? Because they're interpreting. So the first case that we're looking at here is McCrane v. Doherty, and this is from the era of the Teapot Dome scandal. So this is 1927. This is basically the biggest scandal that we had before Watergate. It has to do with basically like financial fraud and deceit. The Secretary of the Interior leases reserves without competitive bidding because they're getting we're still in the legislature. So the first part, see if you go to the first part of the slide, it's congressional powers of investigation and impeachment. So we went through talking about kind of more basic powers of the Congress and limits on those powers. And now we're going to talk about particularly its investigative powers, and then by extension, its impeachment powers. All right. So basically, this is just an example of a sort of high-ranking official using their power to be able to get some sort of private revenue. Okay, so they lease reserves without competitive bidding because they're going to get some sort of payback, right? This leads to an investigation which shows the fault with the Secretary of the Interior, but it's kind of stopped. I mean, it's clear that other people are involved. They're just not necessarily revealed. What comes out then
is that this is a story about branches checking each other. Okay, so the original fraud, or the original scandal, it kind of begins in the executive branch, or because it's in the administration of the president. The question is, how high does it go? And so what branch of government, so what is, if we look at the way checks and balances work, who is going to step up to the plate and look at this fraud that's happening in the executive branch? It's the legislative, right? And the question is, how high, right, did this corruption go? So the Senate, actually, which is a part of the Congress, but especially it is the most, it plays the most aristocratic role, right? Because there's two per state. It's not based on popular representation. They, in particular, really want to check the executive on this point. And it even goes so far, right, as to show that maybe the Justice Department, which is a part of the executive branch, is implicated in this. If not in the corruption itself, then in the cover up. So eventually, as time goes on, the Senate committee that's dealing with the Teapot Dome scandal begins to sniff out problems in the Department of Justice. And the Department of Justice, again, is a part of the executive. And so they decide, so that this is an example of their investigative powers. They're figuring out that this corruption goes higher, right, than they thought it did, perhaps even into the DOJ. So they're going to subpoena the brother of the attorney general, right, to get down to basic information, to be able to see how high up it goes. Now, the brother of the AG refuses to come. He doesn't answer the subpoena. And so there is a deputy sergeant at arms that is in the Senate, right? And he actually has the power to arrest, or at least it seems he does. And he arrests Doherty basically for contempt because the Senate issued this subpoena. Doherty didn't comply. So then the Senate issues a warrant for his arrest. The Senate deputy sergeant goes and arrests him. Doherty says, I have a writ of habeas corpus. That this process that I've gone through, that where I'm being arrested for not complying with the Senate subpoena, is not part of due process. Basically, like they've overstepped their boundaries. And at first, the federal district court agrees in a little bit, sweetie, in a little bit. First, the district court agrees. Yeah, that makes sense. One of the things that should come to mind for you here is our earlier case, Young v. USX Raton. And that was the case, remember, where they were debating whether or not the Senate could appoint a special prosecutor who had been connected to the Louis Vuitton company, right? So this is similar. That case was something we looked at from the perspective of judicial power. This case, McGrain v. Doherty, we're looking at from the perspective of the legislature. So these are the issues. Can Congress compel a private individual to appear to testify because, right, this is a part of how it executes its legislative function? So basically, do we have this power of subpoena, congressional subpoena, because in order for the legislature to function,
their subcommittee, their investigative subcommittee has to be able to subpoena. That means require someone to come and testify. Okay, and the second issue is, in this case, was Congress acting to obtain testimony? So you'd have to say, right? Like, let's say that you do agree that Congress can compel a private individual to come and testify. You'd have to show that it was something that was being done because it was necessary and proper to some role of the Congress. And so the second issue is, well, what's a legitimate role of Congress? Well, a legitimate role of Congress is to obtain testimony. Okay, so in this case, is Congress acting to obtain testimony? Because if they aren't, you can't make the argument about the necessary and proper. The answer to both issues is yes. So yes, Congress can compel a private individual to appear to testify. And yes, in this case, Congress is acting to obtain testimony. So again, there's no sort of blatant provision that permits this in the Constitution, but this again is a case about necessary and proper. We know that the power of inquiry is essential to legislative function. So think about it. If you're writing legislation, or if you have the subcommittee that is set up to look at fraud in the executive for the, either through investigative or impeachment powers, then having the power to inquire is a part of having those explicit powers. So the power of inquiry, basically, it's essential to the explicit powers that the legislature has. And if there's a power to inquire, then that means that there also has to be the power to enforce. You can't just say, okay, Congress, you have the ability to investigate. In fact, that's your constitutional duty. But yeah, if someone just wants to say whatever, I'm not going to show up for that, then they can do that if they want. On this interpretation, the right of enforcement goes along with the power of inquiry. Information, just generally, in order to legislate, you need information. So the investigative abilities of Congress really matter. One interesting thing about this case is that it really focuses a lot on the function of Congress. So the practices of Congress as established in how they have worked out a way to carry out their constitutional duties, rather than inciting the Constitution itself. Okay. Watkins v. United States. This is another case about investigative powers. HUAC. Do you guys know what HUAC is? It's the House Committee on Un-American Activities, right? So this is back during the Red Scare. And actually this lasted pretty long. It was created in 1938 and it lasted until 1975. This was a committee basically to sort of figure out the extent to which communism had infiltrated America. And I mean, there were a lot of things wrong with it, and obviously it was extremely problematic, but you have to remember that it's the context that it originates in is a context, right, where you have the Cold War and the rise of nuclear power. And so this was how the Senate decided that they were going to handle this, is to see like who's a communist and who's not. And actually, like if you still take a citizenship test, there are questions on there about whether or not you're a communist. So there's some sort of long-lasting legacy. Okay,
Watkins v. United States. There's a labor union organizer who is testify. He's summoned to testify, so he's subpoenaed basically. He needs to comply, and he's supposed to talk about his involvement in labor unions, and not just his involvement. You know, sorry, baby. Not just his involvement, but also the involvement of other people, right? So he's not just supposed to talk about what he does. He's supposed to be able to answer questions about other people too. And he says, look, okay, I'll tell you about what I did. But I'm not going to talk to you about other people. I'm not going to talk to you about former members. That is the people who you have questions for me about, that participated in the past. They are not a part of the scope of the committee's inquiry. So basically, what you have the authority to look into, you're trying to get beyond that. So of course, the HUAC cites him for contempt, and then he gets convicted in the federal court. This conviction's upheld, but he appeals. And what the constitutional issue is whether or not Congress has the power to compel testimony under the legislative function in a way that extends beyond what is pertinent to its investigation. So basically, how far does Congress's power to compel testimony go? Does it go so far as to go beyond things that are not immediately pertinent? And the answer is no, it doesn't, right? So they're overstepping. Congress, they say, has broad abilities, right, to conduct investigations. However, they just don't have like a blank check. There's not carte blanche to just conduct any inquiry whatsoever that they desire. They have to connect it to a legislative purpose. Okay. And their power to compel, then, if inquiry is connected to a legislative purpose, then the power to compel inquiry also has to be connected to a legislative purpose. And you will see that sort of legislative purpose in the authorizing resolution for the subcommittee. So you go back to its authorization and you see what legislative purposes are laid out, and that's how you know the scope. If we go back to the authorizing resolution of the HUAC, we see that Watkins is correct not to answer, okay, that this does go beyond the scope of the legislative purpose. And if all of this is true, then he has a Fifth Amendment right to due process that's being violated. And one thing that's important to recognize about this case is that Watkins occupies a special status too, because he's a private citizen, right? So he's someone who's being called up. He doesn't work for the government in any capacity. He doesn't work for the military. He's a private citizen, and that's important to remember. One thing that the government tries to say is that, look, you have to look at our intentions and not just on our actions or on our process. You have to look at why we're doing what we're doing to understand the legislative purpose. And the court says, no, I mean, it's impossible to read intentions. Like, this is not something that is within our capacity. The only thing we can look at is the process that you went through. So the way that Congress reacts is it freaks out. And remember, they have some control, a good deal of control over what the Supreme Court's jurisdiction is. Oh, I see someone in the chat. NB. NB means no. I'll just type it out. It's Latin. Sorry, that's all caps. I'm not yelling at you. Nota bene. Okay, it's Latin. It just means note well or pay attention, basically. It's just something that I use sometimes when I'm thinking or writing, that you'll see in other places too. So Congress, of course, is like, and let me know. Yeah, that's a good question to ask. I'm glad you asked that. So Congress reacts by withdrawing the Supreme Court's jurisdiction over committees and subcommittees of Congress and over contempt charges. But the Senate tables that bill, and eventually, actually, the HUAC is seen as not constitutional. I want to make sure I spelled this right because I did not spell it right. Under the Fifth Amendment, so under due process, right? And when that happens, Congress's attempt to change the jurisdiction of the Supreme Court, it kind of changes, it drops out, right? Let me look. One of the things I wanted to do with you guys was to look at impeachment. I guess I'll start a little bit on impeachment. I won't get too far into it because we don't have a ton of time. But I basically want to encourage you to think about impeachment powers in the same light that you think about Congress's investigative powers, except that the impeachment process is really clearly spelled out in the Constitution. This is an example of one of the reasons why I think when we talk about separation of powers, if we really reflect on it, we see that each branch has characteristics of the other branches, because the way that the impeachment power is laid out, like its actual process, it turns the legislature into basically a little court, where part of the legislature takes on the role of prosecutor, which of course involves fact finding, right? Investigative powers. And then they can then subpoena people to testify, right? If they summon them and they don't come, they can make sure that they come. They're obligated to come, and if they don't come, then they're in contempt. But then another part of the Congress will play sort of like the role of the judge or the jury. They're going to listen to the charges that are written up. Then they're going to listen to the evidence found about the charges and that support the charges, and they're going to decide, okay, are they guilty of what they have been impeached for? So impeachment is a very special sort of hybrid power. In some ways, you might think about it as like the ultimate investigative ability. So I'm just going to go over this slide, then I'm going to let you go. The ultimate investigative ability. So impeachment, it sounds confusing. Probably the best way to think about an impeachment is to think about it the way you think about the word indictment. Like you're basically saying, these are the things that you're accused of doing, and we have enough evidence to indict you for it. Only the House can do impeachments. Okay. So they bring the charges up. And those charges come before a simple majority vote, right? So sometimes, right, you could bring charges, I guess, if you wanted to, like there could be evidence, but if there's not the enough votes, right, to reach a simple majority, it wouldn't be something you would undertake. It doesn't matter how much evidence there is, because at the end of the day, this interfaces a lot with partisanship. But Senate is the one that has the power to try the impeachment. So it's the House that impeaches. It's the Senate that tries that impeachment. So basically, they listen to the indictment and the evidence for it and they determine whether or not the person is guilty. So there's a simple majority to impeach in the House. To convict of the impeachment in the Senate, okay, you would need 2/3. Now, one thing that happens is that impeachment is for high crimes and misdemeanors. That's what it's said in the Constitution. And that means that impeachment doesn't have to be for breaking the law. It can be for breaking the law, right? But that's not the only content. And so you can see that there is some leeway here in terms of what the legislature is able to do or define. It's also the case that a lot of times, rather than actually be found guilty of impeachment, of what you're impeached for, when after you're tried, the expectation is a resignation, right? Because it's just very, very, very disgraceful. But if you think that you can get through the Senate without being found, responsible, basically, then you probably aren't going to resign. Okay, all that being said, we're just going to spend a little bit of time talking about impeachment, and then we'll wrap up Congress's powers, right? We'll go through Schechter v. Poultry, Schechter Poultry v. US. I mean, and that's a Depression era case. It has some implications for federalism too. We'll go through Mistretta, which has to do with drug sentences, and then we'll go through Chadha, which is a very interesting, very kind of complex case. So those three cases are kind of like top level complication cases. Okay, I'm gonna let you go. Chat. Let me see. Oh, thanks so much, Lucille, for saying she feels better. Thanks. Yes, Belle, you can though let me stop the recording. Give me 1 second. And then I also have to save the recording to make sure. So give me a second to do that too. That way I don't lose what we recorded. Okay. Thanks so much, Ariana. You guys take care. Have a good break.